Welcome to The Fine Print. This is David Grau Jr. welcoming you to a new episode format that we hope you enjoy. Historically, the Fine Print podcast has been hosted by me or one of the other experts here at Succession Resource Group, where we discuss and unpack specific topics, sometimes solo, other times with a guest who's either an expert on the topic or a fellow business owner who brings a unique perspective. This episode format we're launching is slightly different, which we've dubbed The Exchange. We have a lot of internal dialogue on various topics, as we've got a lot of smart people here with different skills and perspectives and areas of expertise. But that internal dialogue never gets shared, given it's, internal. So the exchange is our chance to give you as the audience a chance to ride shotgun with those conversations, to sit in as the most experienced team around M&A and succession for advisors goes deep on a topic. We're keeping this new format a bit more casual and conversational, which should help you find these sometimes dense subjects a bit more approachable, if not more actionable. With that, let's dive in.
Hi, listeners. Welcome to today's conversation, where we will be diving into a topic that comes up all the time in employer and employee relationships, and that is the topic of restrictive covenants and employment agreements. You have probably heard or made the statement yourself that non-competes or restrictive covenants are hard to enforce. Will the clauses even hold up anyway? So is it worth including in the first place? And that's what brings up today's question or topic of conversation. By this conversation, it goes beyond and just enforceability. We see over and over again that the real trouble starts when there isn't an agreement in the first place. No clarity around expectations, no plan for separation, dispute resolution framework, and when things go sideways, as they can, or easily than most of us want to believe they can, it's usually based on those unplanned scenarios that cause the most damage. So today's discussion will be grounded in real firsthand experience. We are a team of experts who have sat across the table from both employers and employees navigating these exact conversations before and after relationships have broken down. We have all seen what works, what fails, and what gets people into trouble fast. So we will bring the legal lens to the conversation with our General Counsel, who is joining us today and can shed some light on what attorneys actually look for, how they typically approach legitimate business protections and restrictive covenants specifically, as well as some simple ways that common employment agreement provisions either get challenged or can be invalidated. So whether you are an employer trying to make sure that your business is protected, or an employee signing an agreement, or you're just here to hear how typical scenarios play out, this conversation is for you today. All right, so let's kick things off with a bit of an introduction or background before we get to the heavy hitter question, which I introduced as restrictive covenants. Are they enforceable? Should we include them in employment agreements? Let's first make sure that we all understand as listeners to at least know what perspective we are coming from today. What are the restrictive covenants we're talking about? How are they typically found in employment agreements? What are employment agreements and why would we have them there in the first place?
Starting us off, I had a conversation recently around this topic earlier today, and the idea of having employment contracts might feel a little formal, not a huge value add, right? From a owner's perspective, the advisor, it's another administrative thing to do. But it seems like as teams have gotten bigger, right? So the advisory firm grows, the founder goes from having, 100 households to 200 to 300 or 400 households. They can't service it by themselves anymore, right? So they bring in a junior advisor, they push that client service work down, give them the recipe, you guys just execute on it. Well, that's great. But then you fast forward 4 or 5 years and you ask the owner, who are the owners of the firm? And they say, oh, just me. But measured by client equity, like who has the relationship, as you've started checking yourself out of the client service work, as the firm grows and as it scales, you've got to push that work down. And you end up with your client service associates, your lead advisors, building relationships directly with these clients. And your risk then is if you've offloaded that client relationship, and they're executing on your client service model, but if any of those folks ever end up losing their mind, defecting and leaving, they can walk out the door with one of your most valuable assets. So enter the employment contract, right? That if I'm going to start handing off my most valuable asset to you, or sending in our leads to you to take care of, we've got to make sure we've got a good meeting of the minds on what the role and expectation is, how much you're going to get paid for your time and trouble. And oh, by the way, as much as you can own a client, right? But like, who owns the rights to the client relationships? And so that's where I think the employment contract does add some value and clarity, because not writing that stuff down and not creating the clarity is a problem unto itself. And it's not like you and the employee, when you leave, get to sit down and hash that out, like rational people. You're going to end up having to employ the services of a judge to sort that out. And that just gets expensive and time consuming. And I won't say it could have 100% been solved with an employment contract on the front end, but a lot of them could have 100% been solved with an employment agreement on the front end.
And I would say just both legally and ethically, a lot of this is morality. When we talk about restrictive covenants, we talk about three different things. We talk about a non-compete, to your point, Dave and Julia. That's hard. It's hard to say that in any state, by the way, you can't go across the street and make a living. And there are very particular states, North Dakota, we just came across one, Julia, in Oklahoma, right? And California, actually, as you get further west, it tends to get more employee comfortable. But so there's a non-compete, there's a non-solicit, and then there's a non-serve. Those are all different things. And the way that this works in an employee-employer relationship or an independent contractor relationship is very specific to that state and the circumstances around how that agreement is entered into. So we always try to take as much care as we can when we put these together. Again, Julia and I just worked on one, was it this week or last week, Julia, that we were very specific about Oklahoma and a Supreme Court case that came down in Oklahoma that we wanted to make sure that we addressed. So this is what we do when we put contracts together for our clients. We start very industry specific, but then we dial it into where you're located and what those particular rules are.
Just add on to Todd's comment there. So Todd, you talked about what the non-compete, the non-solicit, the no-serve as different layers of what people, I think, kind of generically refer to as non-competes, but those are actually three distinct things.
100%.
And the problem is, it seems like the non-compete doesn't do anybody any good, right? Because we don't really care about somebody going across the street and starting their own firm and competing fairly, right? Build your own book. I mean, I'd probably rather you didn't, but it's fine. The non-solicit's too easily circumvented. If I have all the client relationships, I don't have to solicit anybody for business. I just need to let them know my new name, address, and phone number. And they'll come seek me out, which means I didn't solicit anybody. And then you get to the no-serve.
Right? So, I mean, that's easy enough. And that's been a distinction. That was what Julie and I just worked with last week.
Well, and then the no-serve, Todd, you could probably speak to this better than I could. In the no-serve clause, where you just simply say, I don't care who solicited who. You just can't do business with the firm clients. Even in California, that still is a version, for example, of restrictive covenants, which means it's going to be that way in all other states. Also, if you're listening to us and you're under a broker-dealer, FINRA, Todd, I think there are some rules that might strictly prohibit you saying who a client can and can't work with. Fair?
Yeah, that's a fair statement, but you also have to think about, I mean, we're in a highly regulated environment. So we have FINRA, we have the SEC, we have state regulators, we have the IRS, but there are also state laws that we have to pay attention to, employment laws in particular for this topic. So I think that as we look at every single engagement that we do, when Julie and I are talking about a particular person in Minnesota or California, then we pay particular attention to where they're located and what those rules are.
So, quick question for the group, more specifically towards Julia and Todd. So, in my role as the valuations director, I probably have the most conversations with people around employment agreements because we do hundreds of valuations. And last stats that I pulled based on our valuation feedback, 85% of the firms out there that have employees working for them do not have employment agreements, even less have restrictive covenants. So yeah, that's 85%. That's a majority of the industry doesn't have any protective restrictions around what they've communicated to their employees, what their expectations are, what they can and can't do with clients post-employment. So a lot of people that I talk to understand that risk. You're right. That's something that we've been needing to do. Most people see it as kind of a low value item. As a result, what they tend to want to invest into it is very little time, effort, and money. So they have this expectation that I'm just going to go to my attorney. I'm going to have my attorney basically reach into their server, send me some template agreements. I'm going to slap some names on it, customize it a little bit, and poof, done, box checked, moving on to next. So the issue there is you're not actually addressing the risk. There is quite a bit of nuances that go into an employment agreement in general, even more so in this industry because there are clients that are generally going to follow you around. So for example, close friends, close family, what do you do with those? Because those generally, if I'm bringing in my mom and dad, grandma or grandpa as a young advisor to a firm, the likelihood that they're going to go with me when I leave is pretty high. So with that, there needs to be specific carve outs for what happens to certain clients, what is acceptable, what isn't acceptable. So background for the question. Now, the actual question for you guys is, what are you typically seeing in practice, and what is the process when we start the engagement of talking with employers about getting the employee agreements in place? So are we just handing out agreements, or what's that process like?
So we obviously come to the conversation with industry tailored agreements as a starting point, but to answer your question, Ryan, they do become tailored to the specific employer or the business that you are employing employees under for those specific types of scenarios that are unique from business to business or employer to employer. You may have advisors who, for example, don't have any immediate family as clients, or they haven't brought anyone in specifically through their own effort. So maybe it's not a quote unquote concern or something that you feel like you need to address at this time. But if things like that come up, to Dave's earlier point, it's nice to have the communication there so that the answer is there before you really even need it to address those types of scenarios. The reality is you are likely going to allow that advisor, if they terminated their relationship with the employer, to take or keep those relationships as their own, those immediate families, client specifically. But if that's not written down, that's going to be a question or a concern of the advisor upon departure or contemplated departure. So it'd be nice to have that at least written down and acknowledged in the first place. That's obviously, I would say, low-hanging fruit, not a big concern because you're going to allow them to take it anyways. But the point is that that's just one item that's important, or would be nice, of course, to have documented and acknowledged as essentially a benefit that you are acknowledging you are offering, and your employee to acknowledge that they have that flexibility. And then that helps support then some of the distinctions around what is mine versus yours, as in this is company property versus we're acknowledging that you would be able to take this, whether it's immediate family or in a specific group of clients that we acknowledge as the employer you have brought in with your own efforts or at the start of your term of employment with us. So we want to make sure that it's documented that these are yours, you brought them, just like your immediate family. We know that we will let you take them if you were to ever terminate your relationship with us. However, just these specific clients, because the rest are company clients, you may be working with clients that you don't, quote unquote, have the ability to leave and take with you. So we want to make sure that to the extent that that exists or could exist, that that is very clearly addressed. And the best place to address that, of course, is an employment agreement.
And I'll jump in here from the transaction side of things. So, my team, of course, we help with peer-to-peer transactions, but we also help with internal succession planning. So we've talked a lot about, whether or not someone might leave, right? But that's one variation, which of course is critical to address. The other is to say, hey, you continue to perform. We want to bring you on as an owner in a successor capacity. And by the way, we have a contract here that showcases and illustrates it. you actually have some sort of division of equity. You have some acknowledged equity in client relationships that you might want to merge into the practice, right? So help to support sequencing and structuring for succession planning and, corroborating any acknowledged equity that may be in play as one of those building blocks in the process. So we do like to mention that from the succession side. And I've had certainly engagements where Gen 1 is saying, oh, we own everything outright. And Gen 2 is saying, well, wait a second, I thought I had my own little carve out here. There's nothing on paper to distinguish this. So suddenly we have to address it, come to some sort of agreement. It can muddy the waters or present new challenges to succession planning that no one was even, thinking about before the process started. So that's another variation of that I think is really impactful.
I think both of you guys have hit something on the head that's really important. So we call it equity, right? Client equity. And that's how we design our documents and then integrate them into whatever state law is appropriate for each client. But I don't know that I have ever seen anyone before I came to SRG who did that. That was really interesting to me. It was an epiphany because as I'm a FINRA arbitrator, so I've heard court or cases about this stuff and I've had to rule on them. And if I would have seen something where someone had equity and an employer said, hey, you can take these clients, you can't take these clients. I'm being fair. That's what it's all about. It's about being fair and reasonable. And I think what we do, Julia, specifically you, and the contracts and the consulting that you do is you explain what is reasonable and what's not reasonable. And then our clients make a decision.
Really having that lens, right? The FINRA arbitration is, of course, very critically important here to the industry. So really good insight there, Todd. One other factor I wanted to add on to my last point as well, just to close it out, is another, less common or an even more less common instance, which is to say, your employee or your contractor, they may have this acknowledged equity in this pool of relationships, and you can actually have buy-sell terms embedded into that agreement so that you can acknowledge, hey, if you brought these clients to the firm, they have no one else that they're generally going to work with. The likelihood is we'll retain them after they've been working under this umbrella for a period of time. If something unfortunate happens to you, well, hey, we want to compensate you for that. And we've got an agreement that outlines the terms for that. So again, we have a strong basis and just an easy plan of action to address that outcome.
Yeah, I'll piggyback off of Parker as well on, as a sell side representative for our services. I have a current seller right now who is the primary owner, 90% in their business, but then has granted, and I use that term lightly, 10% ownership to Gen 2, And so as we're working to sell the firm, we were trying to figure out what agreements do you have in place? Is there tag-along rights? What are we doing here? Because we need to make sure that we're taking care of this person. And the Gen 1 owner basically was like, oh no, it's just a handshake deal. We just verbalized that they have ownership and you can see it on the 2025 tax return. Okay, well, unfortunately, if there's nothing in writing and it's simply just stated on a tax form, that individual may not actually have any equity at all or ownership at all, and maybe paying taxes on income that they may or may not be receiving. And when it comes to the sale of the business, right, who's the seller? The seller is the person that's on the operating agreement. And there's no other agreement, employment agreement or otherwise, stating that this person has ownership. So now when the practice is sold, they're the one that gets all the revenue, even though this Gen 2 hypothetically has 10% ownership. Ownership in what? And so this, again, is where the employment agreements could be super valuable. So not only on the Gen 1 side are you protected, but also on the Gen 2 side, you actually have something tangible that you can use and say, hey, I own, or have the rights potentially to own something, and I can actually get value out of it at some point in time.
Great points. And by the way, anyone who's listening to this, I think it's really important to understand that these are literally just our internal conversations that we have. Sometimes they're conversations. Sometimes I would say they're arguments, but we work things out and get things back to our clients in the best way possible. But these are the conversations that we have internally, and I really am excited to be able to share these with everybody. There are 2 different statutes in every single state that I've looked at where we're talking about buying and selling a business or ownership in a business and employment stuff. So mutually exclusive of one another. I can tell you that the way that we do our consulting and the agreements, how we define equity. And David, to your point, where we say, hey, you have these clients, take them. We're good. And there's another set of clients, take them, but you have to buy them. I have not seen an arbitrator or a court have a problem with that. And if I were presiding over it, I would not have a problem with it either. It's an interesting and I think an awesome way to approach the subject because it's difficult, right? So if Parker leaves, we want him to be able to, make some money and be able to provide for his family. We don't want to prevent that. No one wants that. And that's the way public policy is. Again, especially as you move further west. And I'm the most apolitical person there is, but obviously red and blue kind of influences that a little bit.
Yeah. And Todd, I wanted to chime in here as well as it relates to liquidated damages, right? This agreed upon price that we might pay if we attract away clients that are not designated as under our ownership. So the other layer to that consideration is not to be too aggressive with that calculation. Sometimes folks say, okay, this is wonderful. Let's put a 5x revenue on that. Well, it does have to be rooted in what could be considered reasonable to market. So the further outside of that bound you go, the more likely you may have potential challenges in enforcement or modification to what's enforceable.
Yeah, 100%. And by the way, I've seen what Julia does in her notes, and she does an incredible job about kind of talking to people about that particular topic.
Typically, I like to tell clients, you do want to be the most reasonable party in a very unreasonable circumstance, which is what we're describing. Unreasonable meaning, hopefully, any employee that you are currently employing would acknowledge that they are not their clients to quote unquote take or continue to work with, even if it's the client's choice to work with them, unless there is payment or acknowledgement of that relationship. So that's the unreasonable scenario that we mean or that we're referencing. And you being the reasonable party, to Parker's point, is making sure that the terms essentially that you are setting and what we would qualify as a buyout clause, whether or not there's actually any non-restrictive covenants in the agreement in the first place, the important piece here is to have that buyout language to make sure that we're addressing not as an encouragement to take clients that are the companies, but if you choose to work with the clients, whether they came to you all on their own or you happen to shoot them an email on your way out and take the client's personal information, regardless of how it happened, they were clients of the company. So you need to make sure that you are paying us essentially fair market value is what most of us listening today would be familiar with. So that's really what we want to set the terms to Parker's point around would be fair terms. And the judge isn't necessarily going to be privy to this industry and really know all the things that we all know and hear often, which are multiples, payment terms. So they're going to look to either other independent parties, attorneys, again, potentially individuals who just aren't as familiar in the industry with this information. So we want to make sure that we're not setting these multiples to be outlandish, where if the first information or independent third party that a judge reaches out to says the average multiple 3 times, and you said 5 times or 8 times in this agreement, it's automatically going to be thrown out. And you are now going to be questioned on how legitimate or how fair are your terms in the rest of this.
Yeah. And to that point, Julia, that's where, have an evaluation on the business done to determine what the multiple for the businesses, which is going to be risk adjusted based on various risk factors in the business. That multiple can be the starting place for assessing damages, but that's not the full picture, because that multiple represents the assets of the business, the diversified risk within the business. Now, in a limited scenario where you have an equity transfer of clients that have been taken or removed from the firm, you have replacement cost, time, and energy that has to go into identifying new potential prospects, converting those prospects to leads. Then you have the lead conversion into an actual client, building the rapport and the relationship and the goodwill with the client. So there's an area of reasonable, and there is no definition around what that reasonable is. Just like, an IRS sets the expectation for an S corporation and reasonable compensation. So, take into consideration again that there's a substantial amount of time to rebuild that goodwill with a new client. So if your multiple, I'm just going to use just a round number here, is 3 times for the practice, 3 times revenue, 9 times earning, what have you, on a buy-sell agreement for equity, we're not going to be focusing on earnings. Rather, we're going to be focusing on what is the revenue from that client. So sticking to that 3 times. It's definitely going to be something more than that, but it needs to be within reason. You need to think through how and why you're going to put the number in there. You guys need to agree to it. One other topic that I am asked quite frequently when I'm talking to clients about buttoning up certain risk exposures that do get accounted for in their valuations, such as not having employment agreements and not having restrictive covenants, is the implementation of putting restrictive covenants in place post-employment. So if they don't have employment agreements, I don't have any restrictive covenants, I'm now going to work with SRG. We're going to have those documents drafted. We're going to have them put in place. What is the process for making those restrictive covenants enforceable? So my general feedback, feel free to correct me if I'm outside of bounds here, but one is putting some form of value and exchange in place when you put those documents in place with the organization. So you can either tie that to an annual bonus, year-end bonus. If you have somebody that's going to be promoted, elevated responsibilities gets put in place with that time, which generally also comes with a change in compensation. But simply continuing employment and having them sign an agreement makes it even less enforceable, if it is even enforceable. And then last comment I want to make on the enforceability is about specific states. My general feedback to people is the enforceability is going to vary for any sort of restrictive covenant on a per state basis. So just like taxes, they're going to differ. Now, the general rule of thumb for a non-compete is that it's a first line defense. Now, it sets a psychological impact of, okay, I know I'm not supposed to do this, whether it's enforceable or not. That's a boundary you can decide that you want to cross, but having it in place at least sets that expectation. Enforceability is generally going to be limited to partnerships, executives, highly compensated individuals. So think you've got time and tenure in the industry, you have something unique, special. And for most places, a highly compensated individual is into the 6 figures, usually starting somewhere around the 120,000 plus, if it's even going to be considered for enforceability. Then that next safety net is that no solicit, no serve, where those have much clearer expectations, but they don't have the geographical boundaries. They don't have the time boundaries. They're not disruptive to the person's lifestyle, doesn't force them out of the immediate area, which means, they're not going to, if they're forced out of the area where they live, that's again disruptive. They're not going to be paying taxes in that area. People don't like that. So again, there are layers of defense, but question, Julia, is with getting those documents in place, what are we typically doing in terms of actually making them enforceable, tying value to exchange? And then the other part there is the degrees of restrictive covenants. Should we include all 3 just in case? Are there certain cases where we're just not going to include a non-compete, only have a non-solicit, no serve? So sorry for the compound question, but just want to put that out there.
Yeah, I will respond to the first one, which is the essentially acknowledgement and how do we enforce this from a financial exchange perspective. Are spot on. Typically, my recommendation is let's not overcomplicate it or maybe even cause more concern than there needs to be for implementing this type of, newly either added employment agreement in the first place or clause within an employment agreement that you're updating. So try to tie that to a time when you're having an annual review. You would normally make adjustments to compensation so that there is naturally an adjustment. Again, whether that's through a promotion, just as an adjustment to compensation by way of inflationary increases. But my suggestion would be, if you can, tie it to implementation at a time when there would be a change in compensation. Then not only does it kind of naturally solve that recognition, but at the same time, it feels more natural to your team to ask them to review, re-sign a new employment agreement. You don't have to be sly about it and try to feel like you're sliding something in that's new and should be scary. It can be very explicitly acknowledged that we're working with consultants who are privy to the industry and help us make sure that we are all protecting ourselves and to make sure that expectations are clear between us as employer and employee. And then, maybe even acknowledging the fact that there is buyout language in the agreements that makes sure that there is the clear expectation of, if something were to happen, we at least have a plan of action. So if things went sideways, this shouldn't end in an argument. We've made or acknowledged what would happen. It doesn't need to be, again, sneaky. It can be very much acknowledged that way. I even provide sample language that some employers choose to communicate via email along with the communication of the changes. Maybe they verbally communicate it when they sit down with the team and ask them to sign a new employment agreement. So we are not suggesting that, again, this be a sneak attack on these new terms, but rather an acknowledgement that we are buttoning things up. We are reorganizing all of our, best practices and working with consultants who have best recommendations on how these things actually play out and how we can all protect ourselves. So again, either change of compensation, if maybe you're mid-year or at a weird time, but it's important that you have these in place. If it's important that you have these in place throughout the year, or you can attach that to a change in compensation, you can provide a small signing bonus. So again, we have some language that we can always suggest, but it's a couple $100. It doesn't need to be significant. It's just that acknowledgement that they understand the new expectation that has been outlined in the agreement.
So by the way, Ryan, that was the longest question that I've ever heard in my entire life.
No. Time out. It was a compound
We only got to
question. You
answer
know what a
one more.
compound question is, Todd. There was
Yeah,
two in there. Or it was a long question.
Whoa. I don't even remember half of it. To Julia's point, yes. But look, it boils down to very basic contract law on these things, and the consideration that's given. So that's what Julia is talking about, being able to give something. It's tit for tat, right? So whenever you have a contract, you have to have valid, binding consideration on both sides. If you don't have that, then it makes it harder to enforce legally. But again, I'll go back to my point earlier that there's an ethical and sometimes moral efficacy for this. So when I came over to SRG, David Grau and I have talked about this. I had a 1-year restrictive covenant. And was it enforceable? I don't know. Maybe. Did I abide by it? Yeah, I did. I just thought it was the right thing to do out of principle.
I think the other thing that I want to add is, we're talking about employment agreements usually coming from the owner, and Julia's mentioning like it shouldn't be a scary thing, and it shouldn't. But I think so often there's this misconception that, oh my gosh, if I'm getting an employment agreement, some formalized document that is other than the offer letter, which some people have been like, well, I provided this when they joined. Is that a restrictive covenant? And like, no, it is not. That it should be this bad thing for the Gen 2 or the employee. And in fact, I think it's actually the opposite. It's not only good for the owner of the firm, the employer of the firm, but these employment agreements are also good for the employee of the firm. There's been so many instances when I did valuation, at least, where I would hear, Gen 2, the employees basically saying like, gosh, I've had years and years of sweat equity, and one of these days the owner is going to give me actual equity. Or, they've been promising X, Y, and Z for so long the employment agreement can actually help establish what that may look like to some extent. But in addition to that, I've also heard where the employees state something to the effect of, well, I've been working with these clients now for 10 years. They don't even know who the owner is anymore. So without any sort of agreement, I can just take these clients and run. And that's not really good for anyone, the clients included. So the employment agreement, to Julia's point, should not be a scary thing, but they benefit not just the employer, but also the employee.
Yeah,
Yeah,
and actually, a really salient point there. I wanted to jump in, Kristen, and just add on to that from the acquisition perspective or business value for a seller. So we have certainly seen transactions or heard of transactions where a business is sold and the seller did not have contracts in place with key personnel. And said key personnel decided, well, wait a second, I'm not just going to roll up under some new equity structure. I've been waiting for my equity for long enough. I've got the relationships, like Kristen just said. I'm walking away. And on top of that, there's not even an agreement that says that I'm not allowed to do this. So certainly that's the worst case scenario. And we've actually seen some suboptimal results from certain transactions, not our own, but those that we've heard of. So that can actually be an added benefit for a seller for the, concentration of value there and the retention of value, especially if you have that retention clause as well that could be triggered. So that's another variation of that concept from an M&A perspective that's really valuable.
To address the second question in your compound question, Ryan, which was about layering and non-competes, no-serve, non-solicitation. So our three options we've talked about. Generally, I would say, I'll make the statement that most business owners aren't trying to make an advisor or an employee's life miserable after their termination of employment, meaning they're not trying to say you can't continue working in this industry and be an advisor. You can't continue this role that you are in just because you terminate your relationship with me and the company. It's more just don't be a shithead. So we have generally come from a position of, in terms of what we would address in our agreements, is non-solicitation and the buyout. And that's really to make sure that, essentially we're addressing whether it's actually enforceable, again, a little bit state dependent, or if it's more just used as a deterrent, to Todd's earlier point with the agreement that he signed with SRG in his first year, is just don't take the clients. Don't be scathy and try to reach out to clients and take the list of contact information on your way out. You know that they're not yours. That was acknowledged up front in the initial agreement that we signed. If you really want to work with specific clients or they really want to work with you, probably the likely scenario is you're going to have a conversation with the employer on your way out and ask essentially for permission. Maybe you even negotiate specific terms on what the purchase of those clients looks like. The point of the contracts, and I think an important reminder here, is a contract is really important to have and useful to have when you can't make a different agreement or come to terms. So if you can't come to those terms, maybe the employee did approach the employer and ask for what I'll call as permission to purchase clients. If the terms can't be met or the employer says, thanks for asking, but no, then we have the language, that buyout language in the employment agreement in the first place to at least establish what we predetermined as those terms. So most likely scenario that I like to remind advisors and employers that I am typically working with is we are covering the worst case scenario agreements that we want to revert to. Best case scenario or likely case scenario is you're going to negotiate with the employee. So back to the answer to the question, we typically just approach this with a non-solicitation. Don't take the clients. However, if you do, we have the buyout agreement.
Yeah, Julian, you do a phenomenal job at consulting with our clients on this particular issue. And this is probably a totally different webcast, but we're talking about non-solicits, restrictive covenants right now. But then we go deeper into proprietary information or confidential information. Those are different buckets that we have to pay attention to in an employment arrangement.
So do you guys see with the employment agreements, because you bring up a good point there, Todd, with the confidentiality, non-competes, no solicits, so the restrictive covenants, and then the actual employment agreements, are these three separate, distinct documents? Are they all one document?
Question. It's one document.
In that one document, or we should, at least if we don't already, are we going to have a shithead clause in there? Because I think we should have that now, officially moving forward.
And we're going to put one in your contract.
So my question for you, Julia, you mentioned non-solicits, but we talked about the fact that we don't use them. This is a leading question, and you probably know where I'm going to go with it. So if we do include a non-solicitation clause in there for most contracts, what are they not supposed to solicit?
They are not supposed to solicit, before I count them, let me just list them. Clients, any employees, and then specifically COIs. So if you have relationships outside of the two that I just mentioned, we want to make sure that you're not soliciting, or the idea is that employer wouldn't want an employee soliciting those specific relationships. So 3.
If they take clients, right, we have buyout terms for that. It's pretty easy to measure. There were 100 households, 75 of them followed you out the door. They generated $1 million in revenue. That's easy math. If they leave and they take a couple key team members with them, I feel like I don't feel like, I know I've seen that in most employment contracts, and you can't take employees with you when you leave. I know we have it in ours, but I'm using this as a springboard because we've made some updates, over the years to improve these documents. Most of the agreements I've seen, and by most I mean all that I can remember, just say you can't do it. But then you get down to, okay, Todd, this gets back into your world. You can't do it. You did do it. So now what? All right, well, if we don't have any way to calculate the damages we previously agreed to, then we're going to go sit in front of a judge again. Julia, how do you tackle that in our documents?
Essentially, what we will address in our documents is a fee, essentially, of the compensation of the employee, for example, that maybe the ex-employee, we'll call it, has solicited and now taken. So if an employee leaves on good terms or not, and they start soliciting and telling all of their past employees or peers that worked for the same company that, hey, you should come and join this company, we do have language in our agreements, for example, under that non-solicitation for, cause for damages, which is a percentage of the employee's compensation, for example. So it's going to help support the time then that it takes your now ex-employer to go rehire an employee potentially, because sure, the employer, you can think you're going to fight that employee and say, no, you can't take this employee in their hours. Likely, if the hook's there, the employee's going to leave, or the relationship is potentially damaged anyway. So consider them gone if they're even considering leaving in the first place. From that perspective, now obviously you as the employer, you're out an employee, actually 2 employees at a minimum in this scenario. So there would be costs incurred to cover. Ideally, what we're trying to capture is the time that it would take to go find someone else to fill that position.
Right. I think it's something I pointed out, not so much as, like a sales pitch here to convince all of you listening to hire us. You're smart people. I'm sure you would anyway. More from the perspective of, you're going to put in things that you can't do. And I'm going to hand the mic over to you, Todd, on this one. If you say these are things you can't do, but you don't then build in what happens if you do it, you're setting yourself up to be sitting in front of a judge, which is going to cost all of us a whole bunch of money. And so in the example Julia and I were just talking about, they leave and take an employee, there's some very real costs that you all know as employers. I have to go hire a recruiter. Recruiters aren't cheap, right? Like, I need to fill this role fast. I mean, recruiters charge what, like 20, 30% sometimes of the first year salary? Like, if you took a $100,000 employee, ex-employee just cost me $30,000. That doesn't, Todd, sound very fair or equitable.
Wow. You had the second longest question besides Ryan today. Don't even know how that's possible, but yes, you're correct. So what we try to do is we have a metrics of how we quantify that. All of my attorney friends, both of them, because I don't like attorneys, we agree that if you don't quantify something in a contract, then it doesn't really mean a lot.
Yeah.
So we try to do that in our agreements and the employment agreements that Julia and her team does. I think that's light years in advance of what I've seen otherwise, not just in the industry, but in general. I don't get paid based on how many employment agreements we do, so I don't have a dog in this fight, but I think you guys who are listening should definitely come to us and let us help you out.
One of the other things I'll mention that, Todd, you'd probably know better from your previous role at your previously unnamed large independent broker-dealer firm is one of the firms that they bought, I used to do a lot of work with, I could say, because they're out of business now, Lincoln. They had a ton of split business cases, right? Where like you and I worked together and we got a ton of split cases with a lot of folks. And I've got 75 split arrangements and 75 different rep IDs. There's a group there that I worked with that had come to me, and their challenge initially was none of our advisors know who owns what client because they follow that old MDRT 20-20-20 split. Promise there's a question coming. How in the world do you solve for that? I mean, is that a case where you think the employment agreement would be a good enough solution?
I think it's a solution. It's a great way to build a business, to be able to have split rep codes with folks. It's a terrible way to put together a succession plan or an M&A deal because you have to figure out whose clients are who has to sign off on this. So it's more manageable with employment agreements, and that's what we try to do. But then when we actually have a deal, when Parker's working with them or Kristen's working with them, we want to make sure everybody has their sixes taken care of. I'll put it that way.
Yeah, and just to add another layer to that briefly, we were speaking about broker dealers or different affiliation types. Certain firms will state outright as a blanket statement, this type of registrant owns the clients, this type of registrant does not own the clients, but we can absolutely have a legal agreement amongst each other that says, well, the broker dealer thinks about it that way, but you and I have agreed that I've bought and you've sold these clients, and therefore, I retain the equity right. We're not going to fight about that if I look to walk away. I've got the paperwork right here that says, there's no conflict in that departure.
That's 100% correct. And Parker, I'll add on that and even say, I've never seen a broker-dealer wealth management firm that would say anything otherwise. Obviously, their interest is to keep the assets. So if it's internal, then they're going to make sure they can take care of it.
I'd also just add that it's a valuation nightmare in situations like this, especially if the broker dealer says, oh, you advisor A on these clients, but then you all have a different split or a side agreement. The broker dealer is going to step in and help you all out at the end of the day. And if there's conflicting agreement, then you're kind of up a creek. So, and what I can say is when people are doing valuations, whoever is doing the valuation typically thinks that they own the client and the client relationships and the revenue. Whether they do or don't, I don't know sometimes, but there has been plenty of cases where, you talk to one person, they're like, oh, well, I own these relationships. And then all of a sudden the arguments ensue and you're like, okay, I think you guys need to work this out because there's not much we can do here if you're asking for a true valuation. Ryan, you probably know that better than I do if you wanted to expand, but it is definitely a nightmare.
Valuation for over 13 years, done close to 10,000 valuations. I've got PTSD when we start talking about revenue splits and shared relationships.
All right, I'm going to bring us home then and make sure that we have a very explicit answer to the initial question and the whole topic of today's conversation, which is, are they enforceable, restrictive covenants, that is, and should you have them in your employment agreements in the first place? I will start here in saying, 1, make sure you have an employment agreement in the first place. 2, are they enforceable? Probably yes. If they're not, like the California, like Oklahoma, like some of the other states that are following suit, if they're either knowingly not enforceable or there are complications or fees for you including them in the first place, we'll know about it or we'll work with you on it and we can make adjustments to the agreement so that they're not in there to make it more difficult for you But for everyone else, for the general, the short answer is yes. It's worth having them in there in the first place, because we do have language in our agreement specifically that will essentially say or specifically state that the agreement in its entirety is not invalidated if a court decided that it was not enforceable, whether it's the non-solicitation in general or the period of time. Typically, we would say 2 years on the non-solicitation. But if a judge says, sure, I'll allow the non-solicitation, but 1 year, again, it doesn't invalidate the whole agreement. At least we make sure that that wouldn't. So it's definitely worth having in there, as long as, again, it's not a known state specifically like California, where we're going to set you up for failure in terms of potentially having costs associated with including it. But regardless of you having the non-solicitation, the no-serve, non-compete, any of them in any agreement, what's most important is, if you can catch a theme from today's conversation or take anything away, is to make sure that there is a solution in the agreement rather than the statement that you can't do something. So it's that buyout language that we really put heavy weight on. So yes, worth having them in most instances, but if it doesn't make sense, or even if we don't have them in the first place, our recommendation would be to have those solutions in place.
Julie, I will resoundingly say that I agree with you, obviously. And what you're talking about, when we have identified a few states that are more difficult for employers. So to your point, we have something in our agreements. It's called, for the attorneys out there, it's called a blue pencil. So what blue pencil means is that if something's not okay in a particular jurisdiction, then you strike that little piece, but the rest of the document is still enforceable. So that's called a blue pencil. But we also pay very close attention to this because David mentioned it before. It's a building block. Your employment relationship is a building block to a potential succession plan later. So we want to make sure that we're keeping you informed, protected, everything. Obviously, we can't give you legal advice. I like to say we give legal information, but we're here to help you. And we work with people's attorneys, CPAs too, on a regular basis, because they may not be intricately familiar with FINRA, SEC, state regulations on securities. We are. So we're here to help you guys, even on the employment front. We'll do all that we can to help you. So reach out to us.
Yeah. And we've talked a lot about restrictive covenants in employment agreements. And I personally, as somebody that likes to have everything documented and very clear and checklist, like, there's a lot of moving pieces when it comes to hiring an employee. And an employment agreement is a reminder for you, but also a way to communicate various things around employment. So an employment agreement generally is going to contain things like your job title, duty and performance expectations, compensation, benefits, insurance, PTO options. What is the term of employment? Is it fixed term? Is it at will? Or is it for an intern? And as we've discussed, confidentiality provisions. What is your work schedule? So with more employees starting to work remote or work hybrid, setting that clear expectation for what technology, what do you own? How do you transport this in computers or laptops in your car? So protecting that information, ownership of work product, conflicts of interest, expense policies, termination. So if you are fired for cause, what does that process look like? There's just a lot of moving pieces, especially as your firm grows, and you're going to have different expectations. You're going to have different agreements with employees about their location, where they're working, especially if you hire out of state. So having those employment agreements are important to memorialize and communicate those expectations. So they're in place. And if you ever need to reference them, you always have something to go back to.
Yeah. Well, and that reminds me a couple of quick hitters here, since I know we're probably getting close to the top of the hour anyway, is Todd, you talked about the attorneys, industry specificity, our agreements. It's tricky, right? Because if you're going to go get this up put together, who are you first going to think of to put together a contract? Your local counsel. The problem with that is your local counsel, well, they might know you or your business. they don't know the industry. Now, let's just say you reply back to me and say, oh, David, they actually do know my industry. Well, that means that they don't know employment law or regulations, right? Because those are two big bodies that you would specialize in, one or the other, not both. So we tell folks we know a lot
Great
about
point.
a little. So if you're going to lean into your local attorney, that's fine, right? I get they're going to provide you ongoing legal counsel, but airlift us in as the specialists, provide the documents that are built for this industry, for your business with the right protections, and then let them do a final review or at least know what you got in your business. The other one is around enforceability of these things, just putting this out there because I see, well, not as much anymore because Julia does it, but I used to see a lot of folks. We have a 14-day required notice period at the very beginning of the document. It says, hey, Julia, if I'm going to ask you to sign this document, I'm putting in writing now that I gave you 14 days in advance to look at this thing, review it with your counsel, decide if you're okay with it or not. And people would say, oh, just take that out. I don't have 14 days. Well, you need to give them 14 days on the back end should you need to go try to defend this thing. Broker protocol, that one didn't come up. It's not even applicable to those of you listening in the RIA space, generally speaking. But again, this is one I hear people push back on a lot where they say, oh, well, my firm is part of broker protocol, so I can't tell them they can't take the clients. Todd, a short answer on that one. Your thoughts?
Short answer, bullshit.
Thank you.
Broker protocol is a contract that someone has signed. You can sign another contract that supersedes that and have a buyout for sure.
Yeah. Right. So you can definitely contract around it. It's the low bar. And I say last two, and I promise I'll be quick, is I don't remember who it was. Todd or Julia mentioned, and even Ryan talked about the confidentiality terms, work product and ownership. That one came up. It's probably been a year or more now, but we had an advisor firm, pretty large firm. One of their next gen advisors had started a podcast, right? Like that was their contribution. Julia's heard me say this probably ad nauseum, but podcast took off, did really well. It was a good lead gen magnet for them. Well, turns out good enough lead gen magnet. Next gen advisor thought, I'll leave and just go do my own thing. Yeah, Todd knows where I'm going with this as the attorney sitting here. Left and took the podcast. Well, guess where he came up with the idea for the podcast? Guess whose equipment he used to record the podcast? Guess whose computer he did it on? His employers. Guess whose work product it was? Well, one will never know because they didn't have an employment contract, but it ended up being something they were fighting about. And so again, back to, you think about what work product would we have we need to protect? Over years in business, you have a lot that you just don't even think of. Last one, garden leave. We didn't get into it today. We could probably do a whole podcast on garden leave or a whole another exchange around it. But even in places where you can't do a non-compete or you just don't feel comfortable with any kind of restrictive covenant, you're worried maybe even a buyout could be interpreted as a restrictive covenant, use garden leave, right? Julia leaves. I don't have any kind of restrictive covenant, but I have an agreement with her that says whenever you give me notice, I'm keeping you on payroll for 3 months. It's a feature. It's a benefit. Well, I now have a 3-month head start while she's iced out at home gardening to go solidify those client relationships to try to make sure that they stay with me. So I think garden leave is a example back to the comment on working with counsel versus consultants like us that have counsel internal. If you knew to ask about that, the attorney might come up with it. But garden leave is a really simple yet useful tool that you can use in these agreements where you might not even need to worry about buyouts or restrictive covenants. Mic drop.
It is, and I think that that's something that's unique in our contracts that we do. Putting myself back in the chair as an arbitrator, if I'm looking at this and I'm looking at what's reasonable, that is incredibly reasonable.
Yeah.
And then going back, Dave, this could be an entire different webinar series, again, on proprietary information. You touched on that, and confidential information, the data that a company has, that is incredibly protectable.
All right, we've got a few seconds left. Anybody want to try to top my longest question?
Say no.
I think I did, right?
No.
All right, guys, I think this is a great place to close it out for today. Obviously, we could expand on a lot of these topics that we snuck in that could have a whole session to talk about what the benefits of considerations should be, what we maybe should avoid in certain scenarios. We can do a lot of customization and work with you as a future client, for example, in terms of customizing these types of agreements to make sure that they fit what you need. But again, coming from a perspective of making sure that, everything that's captured in these agreements is practical. And that's the key here, that isn't always going to be accomplished through working with a local attorney while there's someone that you probably, hopefully trust, or you are savvy with technology or know enough to be dangerous in terms of LegalZoom, for example. It can work, maybe, but at the same time, it can work as in, sure, it gives you a contract that someone can sign. But what's important is we're putting this contract in place in the first place to make sure that it is practical, that it will help you if you ever need it, and that at the end of the day, it isn't actually scary to your employees. So there are a lot of important topics that are captured in employment agreements in general, in ours as well. So we want to make sure that it's as easy to understand as a non-attorney. And all of us here except Todd can relate to that. So with that, we'll close out today's conversation, and we're happy to chat with anyone more about the importance of restrictive covenants or what we should include maybe in your employment agreements to help beef them up, as well as even some other really important features to make sure that you have communicated between an employer and employee relationship. So thanks for joining us today.
And that concludes another episode of The Fine Print from SRG. We hope you found this episode both interesting and valuable. We encourage you to check out our website at www.successionresource.com. And of course, connect with us on social media for the latest happenings here at SRG. If you just can't get enough of The Fine Print, we invite you to join our monthly webinar series and newsletters where we address many of the topics covered in this podcast in greater detail. Finally, if you enjoyed today's episode as much as we did recording it, please leave us a review, a good one, mind you, and tell your industry friends about us. Your support helps us continue to bring you the best content possible. The information covered and posted represents the views and opinions of the guests or individual hosts, and not necessarily the views or opinions of Succession Resource Group. Content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional advice, as amazing it might be. Always seek the advice of an expert with any questions you may have. As always, we at SRG stand ready to help when you're ready.